Okay, so you're looking to negotiate, try to get rid of some of these collections on your credit report, and you want to deal with the collection agencies. Here I'm going to tell you how to handle debt collectors. I'm going to give you some strategies and some legal tools and some negotiation tactics to help you get those collections removed. Now, first, it's important to understand that to effectively manage communications with debt collectors, you want to use debt validation letters, negotiation tactics, and legal strategies. Now, it's important that you understand that there are relevant case laws that you can use and state in your letters to help you resolve these issues, to help escalate them and get them taken off your credit. First thing you want to do is understand the power of the debt validation letter. So what exactly is that? Debt validation letters are letters that help you, that consumers protect themselves by forcing debt collectors to provide proof of the debt before continuing any collection efforts. So in other words, before they can continue to bother you and say, where's our money? We want our money. We're trying to collect on this debt. When you request to them that they verify and validate the debt, they can't send you anything else until they do that, until they send you written validation proof of the debt. But it's a little bit more than that. You don't want to just want validation and proof. But it's important that you understand that they must validate the debt if you submit a request within 30 days of when they first contact you. So the minute you receive a letter, you immediately make a request for them to validate the debt. And you want to send a letter, and I'm going to tell you exactly what you want in that letter. Number one, you want to make sure you have an account or reference number. You want to make sure that you request any supporting documents about the debt. In other words, you want to request from them the signed contract or statement of account from the original creditor. You want proof that you were in default, and then you need an assignment, that they have an assignment of the debt that they got from the original creditor when the debt was released to them. You also want to ask for a demand of cessation of collection activities. In other words, that's that part I was talking about where they can't send you anything else until they validate the debt. That's what you want to request. So you want to have those pieces in the letter. Now, as an additional pro tip, I recommend that you always send dispute letters through certified mail with a return receipt. That way, you have a clear trail that you sent this request and you sent it within the time frame that the law dictates, and that they can't say they never received it because they have to sign for it. And if they return it, they have to say they returned it, which means they still were notified of some correspondence from you. So that way you have that paper trail. All right, secondly is understanding the eOscar system and the rule of documentation. Now what eOscar is, it's a electronic process that the credit bureaus use to process our dispute requests. But the system limits the ability to share detailed documentation with creditors. So to strengthen your case, you want to send a dispute letter directly to the creditors along with the dispute that you send to the credit bureau. So you want to send it to both of them at the same time. Secondly, if the bureau or creditor fails to investigate your dispute properly, file a complaint with the Consumer Finance Protection Bureau and you provide them the documentation that you have. You can file that under CFPB complaint portal, and then it says file a complaint. It's real easy, straightforward. They're there to help us. Next, it's important that you understand the statute of limitations on the debt, so the so-called debt clocks. Statute of limitations, also known as SOL. Yes, it ain't shit out of luck in this case. This is perfect for you. But the SOL determines how long a debt collector can legally sue for unpaid debts, which is typically between 3 and 6 years, depending on the state. So I say that because there are two components, two aspects, if you will, to what determines how long a debt can stay on your credit report. The first one is the statute of limitations that your state provides, because the states have laws in place that limit how long a collection agency can report a negative a debt on your credit report. So the state has limitations, and then there's the credit bureau limitation, which is tied to the type of debt it is. And so depending on the type of debt, that 7-year clock that we often hear about, it's also 7 years, but there's also an additional, in almost all of them, there's an additional 180-day provision in there too, except the particularly when it's tied to the date of first default. So some clocks start from the date of first default. That means when you first went into default, from the 90 days. Some of them, are tied to the date of last activity. And so I have that information if you want. Get that. I have a link where you can get that, and you can look at the debt clock, and you can figure out where each one of your debts, where the clock starts for those, depending on the state and depending on the type of debt that is involved. Now, of course, with Social Security, bankruptcies, that's always 10 years. But you have to understand that if your state clock expires after 3 to 6 years, if it's less than the 7, the debt can still hang around for the 7 years after the date of first delinquency. Like I said, first delinquency, not default, delinquency. So when the first time you made a late payment and never recovered back from it, the clock starts in there. But it's important to note that when making a partial payment or acknowledging the debt, that will restart the clock. So if you were 3 years in on this, and then you reach out and you make a partial payment, or you do something in writing to say, this is my debt and I want to take care of it, they will start the clock from when they receive that. And so that would do that. So be careful when you're considering paying off debt or negotiating on collections to get them off your credit report. Make sure you know where you stand. So you want to thoroughly review that and make sure you know where you are in the debt clock timeline, to make sure you don't do anything to hurt yourself. And always review your state-specific statute of limitations rules to avoid any unintended resets there. And you can check that. I'll have a link for that as well. Now, you also want to consider this when you're actually negotiating with debt collectors. You want to remember that if the debt is validated and they've done everything they can, they prove that you definitely own the debt, negotiation for payoff is your best option at that point, unless you want to wait around for it to expire and then know where it's at. But if you're nowhere near expiration, or you want to get this off your credit as fast as possible, then negotiation and pay to delete would be your best option. But when you're doing that, consider these strategies. First of all, if you were doing a pay to delete settlement, so while the credit bureaus do not officially recognize pay to deletes, some debt collectors will informally agree to remove the debt from your credit report after payment. Now, the credit bureaus, only thing they need is something in writing that says the creditor is okay with removing this account under a certain condition, like upon receipt of payment or something like that. But the credit bureaus are not involved in that. They don't officially recognize pay to delete settlements, but they will follow whatever documentation is submitted to them. If the creditor says it's okay to remove it, they'll remove it. Now, when you're doing partial payment settlements, and this usually works more with older debts, the collectors may accept a reduced settlement in order to close the account and remove it from credit. If it's third-party collection, remove the report the collection entirely from the report. If it's original creditor and it's in collection status, then we would want them to remove all negative references to the account, or from the account. But you always request written confirmation before making any payments. I've said that before. Remember, don't pay them a dime, not a penny, until that negotiation is agreed upon and agreed to in writing by you and them. Now, it's important when doing this to avoid resetting the statute of limitations clock, so that when you're by doing this, so when you're in the process of negotiating with them, you want to avoid acknowledging the debt in writing at all. So you're never saying it's my debt and I own it. You're simply saying I want to resolve the matter. And so you never say in writing, you never acknowledge the debt, because if you do, that'll reset the statute of limitations as well. So, to be sure, be careful, make sure you don't reset the clock. If you inadvertently do, but don't worry about it if you ultimately end up paying off the debt and it's removed anyway, so the clock won't matter when the debt is gone. But in the meantime, before that's done, you want to protect yourself as best you can by doing that. Now, the next thing I want to talk about is using legal precedents, case law, to strengthen your dispute letters, right? It's important when you're drafting your dispute letters that you cite relevant case law in your letters, which shows them that you are aware of your rights, you know the laws, and that'll add pressure on them, and it'll let them know that they have a less of a chance of giving you the runaround when you know your rights, and they don't want to end up you reporting, filing complaints against them, and then they're creating more problems for them. So there's three case laws that I think are particularly important that you want to add to understand. You want to understand these so you'll know this is where the power is in the laws that allow you to get what you want to get to remove it from your credit. The first one is Cushman versus TransUnion. This case established that the law that credit bureaus must conduct reasonable investigations and not rely solely on creditor reports. Of course, you guys know I've reported in previous videos earlier this year about the lawsuits that the Consumer Finance Protection Bureau filed against Experian and Equifax. They already settled one. Another one was in the midst, and it was my understanding that there was a lawsuit in the wings waiting for TransUnion as well, because it was determined that they weren't doing independent investigations. They were merely repeating what the creditor told them without independent verification on that. It's also important that you understand in Dennis versus BEH-1 LLC that creditors must correct inaccuracies once they've been notified. So when you notify them of an inaccuracy on their credit, and if you've provided documentation showing what it really is, they must correct it. And in failure to do so will constitute a violation of the Fair Credit Reporting Act, and that will subject them to fines, penalties, and sanctions. Thirdly, you want to mention Richardson versus Fleet Bank. This case emphasizes that creditors must respond promptly to your disputes, and that they know that they can be subject to legal action if they don't. The law provides them 30 to 45 days to investigate and respond, and you're letting them know that you know that they are required by law to do this, and that's the legal case that rule is based on. Okay, and so you also, let me talk to you about filing complaints with the regulatory agencies. Understand this: if your dispute is not resolved to your satisfaction, either they're not responding, they're giving you replies, which is common, they oftentimes ignore us, they pretend like they didn't get it, or if they're claiming without validation that what's on credit is true when you still say it ain't, and you've requested validation and verification and they haven't provided, yet they haven't updated anything, you can escalate the issue again by filing complaints with several agencies that can help in your pursuit. Now, of course, the first one I talked about before, I've talked about many times, which is the CFPB, Consumer Finance Protection Bureau. If you file a complaint with them, they can and will investigate your disputes, and they will apply penalties against non-compliant collection agencies. So they will, again, pursue them. If they find it wrongdoing, they will assess fines and penalties. They may even award damages to you if you can prove that you suffered damages due to some inaccuracies that they refuse to rectify. Secondly, you can report them to the Better Business Bureau. Now, while the Better Business Bureau is not a government agency and they can't fine them or sanction them, the Better Business Bureau is a public-facing agency. So when you file complaints with them, they make it public. They publicly shame the company and say, hey, we're getting complaints. Show us what you did and how did you rectify it. And so many companies not wanting that public exposure, that public scrutiny, they may be more inclined to work with you after the threat of that, just to keep things hush-hush and not have a negative impact to their brand and their name. And lastly, every state has an Attorney General's office with a division that works with consumer issues. So in your state, you go to your website and you find the appropriate link in there where you can make complaints against the company in your state or in the state that the company is in, because you can also complain there as well. So you want to search your state's online office support, and that's easy. You can Google that. Now, when you're creating your letters, there's some language in there in the legal references that I think is very important to put in your letter. And I'm going to cite it for you. Now, there'll be a link in there where you can find this, but I'm going to cite this. If you're looking at the YouTube video, of course, you can stop it and you can write this down. But when you're building your dispute letters, it's important that you put this in your letters. Pursuant to the Fair Debt Collections Practices Act, FDCPA, which is Section 15 U.S.C. 1692 G. G as in George. I formally request validation of the debt referenced above. That's your name, the name of the debt, and the account number. As established in Cushman versus TransUnion, credit reporting agencies are required to conduct reasonable investigations rather than rely solely on creditor-supplied information. Continued reporting of unverifiable debt will constitute a violation of both the FDCPA and the FCRA, the Fair Credit Reporting Act. If not corrected within 30 days, I will file a complaint with the CFPB. Now, I always recommend that folks, if you haven't done it before, go to the CFPB, take a look in there, look at the section they tell you about filing complaints. Read it, and that way you'll know and feel that there's an agency out there that will help you, that will look out for you. And then when you put this in your letter, you can put it in with confidence, knowing that you're not just selling wolf tickets, if you will. You're making a promise, a threat, if you will, and knowing that it's backed up and can really be done, so it has some real believability in it. Now, the things that I just told you are essential when you're negotiating with them and when you're creating the letters used to pay to delete those options, right? Now, I've given you verbiage and I've given you strategy and telling you what's key to put in the letters. Now, I recommend that if you haven't done already, that you go to my website and click, and you can either request a free consultation, or you can click on to register for the webinar or any of those. And by doing that registration, or if you buy one of my products, by doing that registration, I will provide you access to my free credit repair platform. It's AI powered. It will, when you upload your credit report, it will read your credit report for you. It will point out all the negative items. It will give you a list of choices that you choose from when you say, what is your position on this negative account? If it's a collection, you say, I paid it, boom. Or I don't owe it, boom. Or I want to validate and verify it, boom. And then it will generate a letter custom for you, custom letter for your account based on what's on your credit report that you can print. It will generate it for you. You can print it out and you can stuff the envelope, put a stamp on it and send it off. Or it'll give you the option to use a service that can print out these letters for you and send them off in the mail at an additional charge. But if you want to do it all yourself, the system will help you with that. It will do all of that for you. Again, it's AI powered. So I strongly recommend you can do that to save you all of this, but you still want to understand these things here, but the system will do it all for you. So if you go to check out the links below, any of those will get you registered so that I will give you access to the free credit repair, free credit repair site. So in conclusion, basically the bottom line is debt validation letters, negotiation tactics, and proper use of these legal references that I discussed. These are all, plus the AI powered platform, are all essential tools for managing debt collectors effectively. But remember, always track your communication with certified mail. So you send those letters out, you send them certified. And again, you're going to mail them yourself, pay extra for the certified. If you're going to use the mail service, certified is an option you can select, and they will send it out for you certified. And it's important that you review the statute of limitations for your state and for the type of loan that we're looking at to make sure that you know where you are in the debt clock, on the debt clock. And of course, you want to do that before you start even thinking about negotiating things. Because if you have a collection and you're 6 months away from it falling off your credit, you may want to wait and save you the trouble. Now again, it falling off your credit doesn't mean you don't still owe the debt. They could still come to you about it. They just can't put it on credit anymore once it reaches the statute of limitations. So understand that. But they can still pursue you for the debt. They can still come after you. They just can't put it on credit. So it's important to remember that distinction between actual debt being resolved and it being off of credit. Now, of course, when we pay debt to pay it off, we're paying off the debt, so we're resolving the debt part as well as the credit part. And lastly, understand that you can escalate your disputes with the CFPB or the Better Business Bureau if collection agencies don't comply and don't act in good faith with you. But I believe by following these strategies, you can protect your rights and avoid unfair practices and negotiate better outcomes for your financial situation. So I hope this helps you. If you follow this, it will help you. You just got to follow through and stay persistent with it. If you like this video, please like it in the bottom below. If you think you're the only one that can benefit from it, share this video with them. Real easy. Hit the share arrow. You can even share it to them via text messaging. You can also, I believe, you can share it with YouTube with Facebook as well, or LinkedIn as well. But I would hope that you like and subscribe. If you got any comments for me, please comment below. If there's any subjects that you want me to talk about in terms of credit, I certainly will do that. So please like and subscribe and comment below. And you'll see me in the next video. Have fun, guys.